Now I'm sitting at the Advisory Council of Nuremberg Academy, and I'm very pleased to chair this important session. This panel will cover the procedural aspect of the Tokyo trial. What were the obstacles and problems of the tribunal? Among the number of questions and issues to focus for discussion, this panel will deal, hopefully, with probably three essential questions. One, evidence and admissibility of evidence. Two, defense rights, as well as translation issues. And three, composition, quorum, and voting of judges, and potential window for dissent. In this panel, we have very eminent four speakers, and each speaker would perhaps have 8 to 10 minutes for their own presentation. And I am going to open the session to the whole floor for the Q&A after they finish their own presentations, basically. Our first speaker is Professor Elizabeth Bhagwat, who will speak on the power of process at the Tokyo trial. Whose evidence? Whose atrocity? Professor Bhagwat is Associate Professor of History and Law at Washington University, St. Louis, Missouri, United States. Actually, now she, notably, one of her books, A New Deal for the World, America's Vision for Human Rights, has been recognized as by many awards, including as the best book in the history of ideas from the Organization of American Historians. She's now working on several publications about Nuremberg and Tokyo trial-related topics, right? Okay, your turn.
Thank you to our conference hosts, Dr. Vivian Dietrich and Director Klaus Rackwitz of the Nuremberg Principals Academy, and especially the very patient Eduardo Toledo. A special appreciation for Judge Song agreeing to chair our panel. What an honor. I'm going to offer 6 points with my few minutes here, wrapping up with a brief conclusion that opens onto some wider questions about the nature of contextualized comparisons across time. Contextualized, Professor Zachman, where is he? Contextualized. The title of this paper references the power of process. With any litigation, procedural issues are the bones that hold up the bodily frame, even as substantive legal questions are always at the heart of our concerns. So to use a different kind of image and to mangle Max Weber, if substance is the coal that fires the engine, then process lays down the tracks that very often dictate where we're going to end up. Even separately from getting in the weeds with any particular set of procedural questions, our overarching concern as lawyers and historians is always going to be fairness. Procedural fairness, in turn, implicates questions of who may be heard and under what circumstances, that is, rules of evidence, as well as related questions of bias and perceptions of bias in the unfolding of the trial and subsequent decision-making that gives us the verdicts. The wider ideology of rule of law also speaks to us about fairness, placing the rights of defendants ahead of other kinds of societal goals, such as truth-seeking in education, for example. Lawrence Douglas's work was referenced earlier yesterday in this regard, and weighing each defendant's situation in light of on an individualized basis in light of particularized demonstrated evidence within an adversary system. Neil Boyster and Robert Cryer remind us that the relevant standard of procedural fairness in 1946-48 was that of military commissions and the standards of fairness for the treatment of aliens on the US side. Unfairness would result if a state were, and this is a quote, to subject an alien held for prosecution or punishment to other than just and humane treatment, prosecute an alien by otherwise than fair trial before an impartial tribunal, and without unreasonable delay, inflict upon an alien excessive or cruel and unusual punishment, and that's, of course, direct Anglo-American language, or subject an alien to unfair discrimination, in the words of the 1935 Harvard Research Group Draft Convention on Jurisdiction with respect to crime. Edward Borchardt, writing in 1919 and setting what was considered to be an interwar standard, lists free access to courts, formal charges, an opportunity to be heard, to employ counsel, to examine witnesses and evidence, and a guarantee of essential safeguards against a denial of justice. All right, so obviously at a very high level of generality, but that these are the due process rights that military authorities were obliged to apply to aliens in wartime. He notes that a number of domestic requirements, again meaning domestic US requirements, such as a right to a jury trial and a right of appeal and other kinds of rights as well, were not required by international law. The procedural rules that the IMT were accordingly based on American military commissions set up for the trial of aliens. I'm going to say that again. American military commissions set up for the trial of aliens. So subsequent history has shown this to be a pretty low bar. And they had recently been reviewed in our Tokyo Tribunal context by the US Supreme Court in Ex parte Quirin, usually known as the German saboteurs case, in 1942. These commissions applied a summary procedure. I think the original saboteurs trial lasted only a couple of days, and denied the accused the benefits of Anglo-American procedural and technical rules. This simple and non-technical approach, in the words of the US Supreme Court, was adopted by the London Agreement for the Nuremberg Charter, and then carried over to the Tokyo Tribunal, as we discussed yesterday. So that was my point two. Where do these standards of fairness come from? The Nuremberg Charter is not engraved on stone tablets. Its provisions were hashed out in multilateral negotiations, but they demonstrably came from somewhere. The Tokyo Charter's guidance for admitting all probative evidence, and while also avoiding undue delay, meant that a great deal of evidence came in, notably from interrogations and affidavits, through this flooding strategy discussed by Professor Cribb in the last session, that we don't really know how it affected the verdicts in any concrete way. While what we have categorized as political decisions, and this panel received very strict instructions not to talk about anything political because we're a procedure, what we have categorized as political decisions about the meaning of the Tokyo Charter kept out evidence of Allied atrocities, again, discussed yesterday, such as the use of atomic weapons against civilian populations, other kinds of evidence about earlier Allied conduct that might have been helpful in substantiating claims of self-defense, for For instance, we have seen how these decisions regarding evidence suppressed some voices, notably pretty much anything to do with Korean victims, and privileged others. Fourthly, and I'm just picking out some points here, okay, because I've been given 10 minutes, but this conference has been so generative that it's already encouraged me to rethink one of the old procedural chestnuts of the Nuremberg-Tokyo comparison, namely the fact that there were no acquittals at the Tokyo trial. The fact that there were 3 at the Nuremberg IMT has always boosted assessments of that trial's legitimacy. And analysts sometimes point to Soviet outrage at the Nuremberg trial about the acquittals as suggesting how the Soviets were intent on, quote unquote, politicizing that trial and did not take rule of law precepts seriously. The possibility of an acquittal is, of course, meant to be a major criterion differentiating political trials from genuine trials. Again, I'm sort of rejecting these, I'm bracketing these categories, right? Talking about some of the literature that's come out of evaluating these tribunals. What the legal theorist Otto Kirchheimer termed the essential factor of irreducible risk. But those 3 Nuremberg acquittals were defendants such as Schacht, who were indicted primarily for economic crimes, a prosecution theory that did not succeed at the Nuremberg IMT and arguably led to the industrialist trials at the NMT, the subsequent tribunals. So we could possibly argue that the Tokyo Tribunal prosecutors just did a better job in framing their list of defendants. We also see how the Nuremberg IMT seems to somehow make it over a posited line of legitimacy, right? Not that it's perfect, but that it makes it over this line where we would say it was certainly better to do it than not to do it, for instance. And a consensus seemed, well, it's being challenged now, but it has long endured that the Tokyo trial is very possibly on the wrong side of this line, certainly before 2008 and the landmark publications of that year, insofar as we can say there was a consensus because there really wasn't that much literature at all, as Professor Totani's excellent keynote speech highlighted for us. But this is a pretty low bar, right? Better to do it than not to do it. Maybe it's better that I get out of bed in the morning than I don't get out of bed, right? But in the more general transitional justice literature terminology, we may see how aspects of the Tokyo trial's design included punishment that was curbed by the intervention of someone other than direct victims, by the deployment of norms such as proportionality and respect for individual rights. And if we continue to have these differing verdicts on the value of these 2 flagship trials, the Nuremberg IMT and Tokyo, we may be able to articulate this intuition more precisely or reject it altogether, which brings me back to the power of process. Perhaps we should be looking to the power of small differences, of institutional design, of cultural context, of the caliber of individual contributions, as well as the procedural framework, which on paper seems to have exceeded what we might call the minimal requirements of this legitimacy line, in the case of Tokyo. So the difference that makes a difference may be how these paper procedural requirements were executed in practice, by which judges, for instance, using which languages, in what way, which some of my co-panelists will address. My final point is accordingly to reiterate that the particular legitimacy stock of a given process may rise and fall over time, right, as was just discussed. And past processes aimed at transitional justice inevitably continue to be reframed by the unfolding of subsequent events, and not just world historical events, but the kind of rethinking I just referenced about the acquittals, for example. So I leave you with these 2 questions. Were the Tokyo trial defendants treated fairly? And compared to what? Perhaps the relevant comparison is not the Nuremberg IMT, or not exclusively the Nuremberg IMT, but other war crimes trials elsewhere in Asia, or indeed later unfolding processes, whether they be South African truth commissions or the elimination of Osama bin Laden. Thank you.
Thank you very much, Professor Bhagwat. That's actually charter in Article 13 provides to the effect that the tribunal shall not be bound by technical rules of evidence and shall admit any evidence which it deems to have probative value. That was the charter's norm. Okay. And the second speaker, next speaker is Professor Kayako Takeda of the College of Intercultural Communication, Rikyo University, Tokyo, who will speak on trial and error in the interpreting and translation procedures during the Tokyo trial. Professor Takeda has received her MA in Translation and Interpretation from the Middlebury Institute of International Studies in Monterey, California, and PhD in Translation and Intercultural Studies from the famous Spanish University. She is the author of Interpreting the Tokyo Trial and the co-editor of New Insights in the History of Interpreting. The floor is yours, okay. Professor Takeda.
Thank you, Judge Song, and thank you very much to the Nuremberg Principles Academy for inviting me to this very important event. I'm honored to be on this panel in this historic room, sitting very close to where the interpreters used to work during the Nuremberg trial. As you may be aware, I'm the only person in this conference whose background is not in history, law, or international relations. I take it that my inclusion is a sign of the organizers' appreciation of the fact that the Tokyo trial could not have functioned without the services of translators and interpreters. The most salient feature of the interpreting... Okay. Can you hear me now? Yeah? Okay. The most salient feature of the interpreting system at the Tokyo trial was that 3 ethnically and socially distinct groups of people engaged in 3 different functions. Japanese nationals interpreted the court proceedings. Nisei, or second-generation Japanese Americans, monitored the accuracy of the interpreters' renditions, and the Caucasian U.S. military officer ruled on disputed translations and interpretations. The IMTFE initially did not plan to use Japanese nationals as court interpreters. The U.S. military's preference of using its own personnel as court interpreters, despite their linguistic shortcomings, was apparent in the Class BC war crimes trials, which were already underway in Manila and Yokohama at the start of the Tokyo trial. The poor performance of these interpreters, however, was a disruption to the proceedings that the high-profile IMTFE could not afford. The IMTFE recognized the need for competent interpreters regardless of nationality or background, which led to the extraordinary decision to use Japanese nationals as court interpreters at the Tokyo trial. About half of these Japanese interpreters were actually associated with the Japanese Foreign Ministry, and the rest were bilingual Japanese citizens, including 2 former soldiers of the Japanese Imperial Army. They were, in effect, working in a trial in which the lives of their former superiors and leaders were at stake. The necessity of drawing on this pool of interpreters was problematic. The tribunal was reluctant to display their dependence on the citizens of the defeated nation, whose potential impartiality could undermine the proceedings. To address these issues, the tribunal devised its hierarchical interpreting system that function as a display of authority and a check against any bad faith harbored by those potentially sympathetic to the accused. In this system, Nisei monitors checked the accuracy or the performance of Japanese interpreters and corrected errors contemporaneously. Disputed translations and interpretations were reviewed outside the courtroom by a language arbitration board, and the final rulings on language disputes were announced in court by a Caucasian language arbiter. The presence of the language arbiter stayed seated in the prosecution area served as a safeguard against suspected disloyalty from the Nisei monitors, and also emphasized that the US military was in charge. Although the IMTFE had seemingly prepared to avoid the interpreting issues of the Class BC trials, it showed at its start ignorance of the demands of interpreting. For instance, the interpreters worked for the first month of the trial without proper interpreting equipment. During a recess in June 1946, an interpreter booth was set up, and the IBM equipment, identical to that used at Nuremberg, was installed. Unlike Nuremberg, however, consecutive interpreting was the predominant mode at Tokyo. Consecutive interpreting on this multilingual scale had no precedent, and the Japanese interpreters and their clients were equally inexperienced. Conveniently, this mode allowed for the many language issues that arose to be discussed during the proceedings. However, it also extended the length of the trial. One issue that arose early in the proceedings was that the interpreters could not interpret long passages or speech read aloud from a document without access to the translation. The language section requested that speakers break down their remarks and pause between segments for interpretation, but President Webb insisted that a summary would be sufficient and full translation would be provided to the defense later. In response to the persistent request from the defense and the language section, Webb finally granted permission for the Japanese translation of prepared remarks to be provided beforehand to the interpreters and the defense, and for sentence-by-sentence interpreting. Also, the trial records indicate that the tribunal had not anticipated the use of a language other than Japanese and English. Relay interpreting for a third language became an issue when the first Chinese-speaking witness testified. In response to the Japanese lawyer's complaints about incomplete interpretation, Webb said, quote, "Well, as I explained before, all the interpretation of every word is not required in the interest of justice. It is required in the interest of propaganda. That is the whole point. I would like the Japanese to understand that the Charter really is mostly concerned with the Japanese people understanding what is happening in this court. It is not required in the interest of justice," end quote. However, 2 days later, Webb announced, "I urge counsel to make their questions short and clear and to keep due notice of any passage from a report or other document which they desire to be read to the witness." Presumably, some discussion on this matter must have taken outside the courtroom. The problems with relay interpreting during testimonies by Chinese witnesses are probably what prompted the IMTFE to ask the tribunal in Nuremberg about the handling of multiple languages in court. A telegram to Nuremberg was sent on 23rd of August 1946, asking very basic questions about interpreting arrangements. The information shared was not very useful because it was all based on the use of simultaneous interpreting, which was not the mode of interpreting at Tokyo. When the French prosecutor and the Soviet prosecutor insisted upon the use of French and Russian, respectively, on separate occasions, significant time was spent inside and outside the courtroom discussion whether the use of non-official languages should be allowed in court at all. After heated discussions, Webb ultimately ruled that the Charter did not exclude a third language, and the language of any of the countries represented on the court would be allowed. About a year after the tribunal convened, Webb had become more appreciative of how interpreting works and how difficult it can be. This was a result of the repeated requests and patient explanations from the language section on behalf of the interpreters and the defense team. The court had to listen to them and come to terms with accommodating the interpreters' cognitive limitations in order to function. In addressing procedural problems with interpreting and translation, the court discussed the speaker's right to speak in a language of their choosing and the mandate of accurate and full interpretation to ensure the defendant's right to a fair trial. Also, the difficulty of interpreting and translation between Japanese and English was explained and recognized, and so were interpreters' cognitive limitations, such as their inability to interpret a long passage in the consecutive mode, and to properly interpret a speech read from a prepared text without access to the text or its translation in advance. Ultimately, the court arrived at workable procedural solutions, such as speakers break down their remarks into short segments. The interpreter delivers a full interpretation, not the summarization. And when the speaker reads from a document, the translation is provided to the interpreter beforehand. Most of these matters are now taken for granted in modern-day international justice, but they had to be learned at the Tokyo trials through a great deal of trial and error. And negotiations between the interpreters and the users of their services. It was indeed a process of the making of an interpreter user. Thank you.
Thank you very much, Professor Takeda. Actually, the importance of accurate translation and interpretation for the tribunals of international nature does not seem to be sufficiently noted. For the ICC, for example, the language issue would be probably single most challenge that would never go away. This could delay the entire procedure indefinitely or cost the court very dearly. You see, in addition to two official languages, English and French, at the ICC, the court has been so far dealing with 10 different African tribal languages. You see, you don't know what language you would have to deal with in the future, depending upon the mother tongue and nationality of the accused and witnesses. So it's a no small matter, but it's, in my view, it seems to be always hidden. I mean, very few just refer to the importance of this matter. Thank you very much for enlightening us on this issue. Our third speaker is Ms. Risette Schouten, of Heidelberg University, speaking on the selection of judges and Dutch representations at the IMTFE. Actually, she is now completing her PhD in history at the Cluster of Excellence, Asia and Europe in a global context of Heidelberg University. Her research focuses on Dutch war crimes trial policy in the Netherlands, East Indies, and Japan. And she is a contributor on this International Military Tribunal trial policies and the background of this judicial activities. The floor is yours.
Thank you, Judge Song, and thank you to the organizers of the conference for inviting me. Very kind, thank you. I'm delighted to be here. So today I will talk about the selection of the judges mainly, and if you have any questions about the Dutch representations, please ask them later. So as has already been said, the Tokyo Tribunal was not only a judicial undertaking, it was in a way also a groundbreaking multilateral endeavor that was influenced by personal, administrative, logistical, legal, and I have to say political factors. Dr. Verlingen already explained to us that the political context finally influenced also the judgment. And in addition, I think it's important to say that the trial was also influenced by more internal dynamics. And I think James Sedgwick has shown that justice in Tokyo emerged from several processes wherein the human element had profound consequences on the trial's proceedings and outcome. Now, the judgment of a trial is greatly, if not primarily, determined by the qualifications and experiences of the judiciary involved. And I think we just have to acknowledge that the importance of the relationship between the process of judicial selection and the success of international courts and tribunals. So today I will therefore focus on the selection of these judges. And the central underlying question is, did the governments use the selection process to shape and influence the judiciary and therefore outcome of the tribunal? And if so, how? Now, the selection of the judges in Tokyo and Nuremberg is different from the selection of the 15 bench members of the most well-known international legal institution of the time, which I believe to be the International Court of Justice of the UN, which had just came into existence a couple months, actually a little bit later than the Tokyo Tribunal. Now, the judges of the INC, they were and they are still chosen by a complex voting system that requires a majority vote in the UN Council and General Assembly. And they are chosen to represent every major legal tradition within the UN. Now, the tribunal in Tokyo, as you know, was a full representation court, a legal body where each of the nations involved had a judge of its nationality on the bench. And I refrain from going into the discussion which nations should have been there, but they were. The tribunal had hardly any guidelines as to the criteria the judges had to meet. And unlike the standing international courts of its time, there was no procedural guidance or external supervision of the choice of judges. We do know, however, that in several instances, the nominating countries were aware of each other's nominations and that influenced the selection process, because countries actually did try to search for candidates that at least had the same professional reputation or qualifications as other nominees or the judges on the bench in Nuremberg. I would like to continue with briefly exploring some of the criteria that we can distinguish when we look at the selection procedures of all the judges involved, apart from the legal or professional qualifications of the nominees. Now, it has been argued earlier during the conference that while nominating their candidates, some governments were not simply picking the best qualified candidates, but they let other factors play a part. And this, of course, can hardly come as a surprise, because after all, international courts and tribunals take away national judicial authority, and two main ways in which parties can maintain control over such legal institutions are controlling the court's budget or appointing its judges. Now, Tokyo, although framed as more or less an international undertaking, it was quite clear from the beginning, of course, that this was, the US would take a leading role. And we might therefore argue that the selection of the judges was actually a possible way for the nations involved to gain some control back over such an institution. The first criteria that I kind of distinguished is the fact, high moral character, right? Treaties that establish international courts, they typically stipulate that judges shall be of high moral character. And for Tokyo, I believe this criterion was especially important, significant for those judges who came from countries that had been occupied either by Germany or Japan. For example, Justices Giranella, Reuling, and Bernard were partly chosen because they had been uncompromised by the war. And in the Netherlands, this, for example, posed a great problem because a lot of the judges had either been working for the German occupation forces and could therefore not be regarded for a position in Tokyo. The second criterion is judicial appointment as patronage. International judicial appointments can be an opportunity for governments to reward loyal functionaries or acquaintances. And according to Yuki Takanori, it was, for example, Truman's trust in John McCormack, the US House Majority Leader at that time, and a friend of Higgins, who recommended Higgins for the position. And in combination with Truman's first-hand knowledge of Higgins, he argues that these were actually the deciding factors to appoint Higgins eventually as a judge. And it has been argued that patronage also has played a part in the appointment of Judge McDougall from Canada and Judge Jaranella from the Philippines. And then the third criterion, I have to confess this is going to be political, I draw from the broad framework of principal agent theory as used in the work of Footen and Alter. Because when we have 11 countries on the bench, it may come as no surprise that the parties involved had different opinions about the proper function of judges in international courts and tribunals. As today, also in 1945, there was a divergence of opinion about the ideal types of judges, and there were countries who expected their nominees to act as what Alter describes as trustees. And I will say, a committed professional with exceptional moral standards who cares deeply about the advancement of international law and is largely unresponsive to material incentives or political pressures. And other countries who saw their nominees as what she calls agents, international judges who are more likely diplomats, who are more like diplomats, and use legal reasoning as a guide for making decisions that fit into the national interest of the governments that appointed them. As Valentina Polina has argued, Moscow saw the Soviet delegation in Tokyo rather as transmitters of the Soviet policy rather than as independent actors. And Judge Reuling's dissenting opinion might be seen as the result of the tension that is created when states are confronted with judges that, once appointed, decide to go against the interest of the nominating state. All in all, I think we can fairly say that while the Tokyo Tribunal was an international trial, not one justice can be described as a truly international judge. And the fourth point is a little bit more mundane. It's simply availability. In more than one of the contributing nations, finding agreeable staff presented a serious challenge. A substantial number of the nations had difficulties to find suitable candidates. Dutch, the French, the Philippines, and the Indian selection process show that primary candidates declined for various reasons. Often only the third or the fourth candidate that was being taken into account was nominated. And the nomination of the Indian Judge Pal in particular seems to have been an act of what we can call pure randomness. And I believe Melinda will go a little bit deeper into this later. Now, the 11 judges that were eventually suggested by the signatories to the Instrument of Surrender, India and the Commonwealth of the Philippines, all had previously held various prominent positions in their home countries, either as judges, law professors, legal advisors, but almost none of the justices had experience with international law. And as we all know, the nominees were later, without reviewing their merits, appointed by General MacArthur. And to conclude the presentation, I would like to briefly make some remarks on the issue that was raised Thursday and yesterday, the quality of the nominees. As Dr. Verlingwen already argued, I not believe that the majority of the nations intentionally selected second-rate nominees. I think it's important that we should not forget that only 4 nations had previously had the opportunity to send a representative to the bench in Nuremberg. So for 7 of the countries involved, it was more or less the first opportunity to be presented on such a stage. And therefore maybe an incentive to send actually a good representative to Tokyo. And the fact that the final nominees had not always been the first possible candidates consulted was in many cases not the result of deliberate considerations, lack of interest, or driven by career incentive. After all, most of the judges were actually already of quite an advanced age, maybe with the exception of Pal and Reuling. Sometimes it were simply medical reasons that prevented one to accept the nomination, or in the case of Canada, where the consent of approval of Justice Hope, the first pick, was declined by the Chief Justice of Ontario because the administration of justice in Ontario will suffer if Hope is absent for 3 months at this time, which is also given an indication of how long they thought the trial would take. And in the case of the Netherlands, the authorities struggled to find candidates because, as I mentioned earlier, Well, some of the jurors had been compromised by the war, others were simply unable to speak English, and in the Netherlands Indies, many were unfit to work because they had been interned in internment camps by the Japanese. So, to conclude, the appointments to the bench in Tokyo might not always have been successful and in some ways are disputable, but again, I think we should be cautious to brand the majority of these appointments as intentionally second-rate. Thank you.
Thank you, Lisette, for your presentation. And our final speaker for the panel is Dr. Melinda Banerjee, who will speak on decolonization in transnational optics, India and the Tokyo trial. Dr. Banerjee is a research fellow of München University, as well as an assistant professor of History Department of Presidency University, Kolkata, India. A global intellectual history of Tokyo trial and other international criminal trials is his main research interest. Okay, the floor is yours.
Thank you, Judge Song. Let me begin by thanking the organizers of this conference for inviting me to this very august space. It has been a tremendously moving and humbling experience to be here. Bengal, where I come from, in the 1930s, Bengalis led by none other than the famous Indian poet and Nobel laureate Rabindranath Tagore were at the center of rousing South Asian and Asian public opinion against the Nazi atrocities, particularly but not exclusively against the Jewish people. And therefore, it is for me very personally moving to be here. It's also, of course, very inspiring to be among so many scholars from each of whose works I've been learning so much for the last few years. It's an amazing experience. However, I would still argue that there is a lot more research needed on the trial. We are still not even halfway through it. And that's because in a trial which had so many actors from so many different parts of the world, one needs much more historical research about all their different biographical, legal, intellectual history perspectives, and so on. Dr. von Lingen started a project in Heidelberg, of which where I started my postdoc, about the Indian participation on the trial, leading up to 3 research essays. I'll summarize some of this stuff here. And now I'm doing a habilitation on what I call a global intellectual history of the Tokyo trial, but focusing particularly on issues of legal philosophy, natural law, and positive law in the trial. I'll speak today only about the Indian aspects of that, but my future research involves a much more comprehensive perspective. Now, one disturbing thing in previous scholarship on the trial, I think, and this has been a leitmotif which has been coming up again and again, is that a false binary has been created. It's as if the demands for international criminal justice or global criminal justice, I'll explain the term soon, is somehow antithetical to any discussion on colonialism or anti-colonialism. And this has been done through a kind of metonymization of Indian participation in the trial through the sole figure of Pal, and then through a very fragmentary picture of Pal. It's posited as if you speak of the Tokyo trial as a colonial project, it automatically delegitimizes international criminal justice, it delegitimizes the International Criminal Court, it delegitimizes any speaking out against sovereign atrocities. And I think this is an absolutely false and pernicious binary to be created. We need to go beyond this binary. The attack on sovereign violence, on the attack on impunity of sovereign actors is perfectly consistent with anti-colonial attacks. And why the Indian participation in the Tokyo trial actually brings this out very clearly, that's what I'll speak in the next few minutes about. My talk will be divided into 3 parts. The first part, selection procedure. Now, the panel abstract says we should focus on legal things and not on political. This is somewhat difficult to do, given that the whole reason why India was at all selected, an Indian judge was selected, was a political matter. Initially, General MacArthur and Dean Acheson, the Undersecretary of State, did not want India and Philippines to send judges to the trial. They only wanted associate prosecutors from the trial. Girja Shankar Bajpai, the Indian agent general in Washington, not only represented the government of India's perspective, but his own personal understanding about the need for international criminal justice. Bajpai is often forgotten, but already in 1942, in a seminal article published in an American journal, he said India should become a part of an international criminal police force to check aggression. And he said this is because Indians are opposed to racism, to the domination of the world by any one race, whether it's an Aryan or a Japanese one. He admitted that Indians in the 1900s had been inspired by the Japanese victory against in the Russo-Japanese War. But soon enough, Japanese invasion of Manchuria and of course Italian invasion of Abyssinia, Nazi atrocities including invasion of Czechoslovakia and Poland made Indians, according to him, very skeptical about the kind of racism being shown by the Axis powers. So for him, that India should become part of an international criminal justice effort was a logical corollary to the anti-colonial Indian struggle, which was, of course, a struggle against racism of any kind. He makes a very interesting transition across the 1940s from being a representative of the British colonial perspective to, by 1945-46, already a supporter of complete Indian self-government. So his stance, therefore, that India should have a judge in the trial is motivated by his idea that Indians have suffered atrocities all across Southeast Asia. Indians have participated in the Second World War, and he says India needs a footing of equality because also that India has a very sophisticated jurisprudence which has already been developed. Now, in the US Department of State, this soon becomes a debate about race. Lloyd Vincent, who is the head of the Near Eastern Bureau, says it looks really bad if we have an all-white tribunal, practically accepting the Chinese actor, judging over Asians. J.C. Vincent, who is the head of the Near Eastern Bureau, he says we should not appear as if we are discriminating against Asian countries. So in the American Department of State, this is a very racial, it's a very political debate. And in fact, many of them actually use the word political. It is a political decision we should have India and Philippines in. And that's how India gets into an entry about the judge. So why is this decolonization in transnational optics? We often tend to think of decolonization as taking part in territorial geographies. India becomes independent in South Asia. No. If decolonization is about the negation of inequality between some countries and others, then I would say one major act of Indian decolonization, India formally becomes independent on 15th August 1947. But in a way, the achievement of juridical equality, what Bajpai calls the footing of equality, happens even earlier in early 1946, when in April, when India is inducted into the bench itself. Now, when it comes to looking at the Indian judge in the trial, Pal, I think he has been very widely misread. And in a way, it goes back to Shklar as well, who I'm very sympathetic to. But Shklar presents Pal as this arch-positivist opposed to natural law positions. And the reason why I think Pal has been very incompletely read is because people have solely focused on the judgment and maybe on the 1955 war crimes on international criminal written by Pal. They've completely ignored almost practically, excepting for a few here and there mentions, Pal's works on Hindu law from the 1920s and his 1950s, 1960s work in the International Law Commission, his lectures on universal human rights, and so on. If we actually look at, and that's what I'm adding as an intellectual historian, if we read all of Pal's works from the 1920s till his death in the 1967, we see Pal actually has a very consistent anti-sovereignty position. He sees the linking of sovereignty and law as something which is basically violent. He comes from a lower caste, lower class, very rural agrarian Bengali background, which makes him very skeptical towards any hereditary form of oppression, whether it's along caste lines or along lines of patriarchy or along lines of racial discrimination. He defines sovereignty as organized power, which is used in different theological as well as secular formats to create brutal discrimination, exploitation, and so on. And that's what he's really against from the 1920s onwards. He also is an advocate of natural law positions. From the 1920s onwards, he creates equations between European Christian ideas of natural law, particularly Thomas Aquinas, with Vedic ideas of Rita and so on. However, in the Tokyo trial, it appears as if he's making a switch, as if he's strategically taking the position of a positivist to defend Japanese sovereignty and even become an apologist for Japanese sovereign violence. But still, it's actually very complicated. There are portions of the dissent which have not been given very careful attention by scholars. Pal says very clearly, I support the 1920 Advisory Committee of Jurists at The Hague who wanted an international court of criminal justice. He says, I agree with this. He says, I agree with Herr Schlauterpacht, the famous jurist, that the role of international law should be the protection of individual human rights. He says, I agree with Hans Kelsen, we need a neutral tribunal. But what would the neutral tribunal be? Which will punish atrocities committed by victor as well as vanquished nations. So the question raised yesterday, is it possible to have something beyond victor's justice? Pal's answer would have been, yes, we need to prosecute whoever commits atrocities. I don't think this is a pipe dream. This is very much possible. In the 1950s and 60s, he delineates even more strongly his idea of global justice. He says this will happen when actors from newly independent countries of Asia and Africa will come together and try to solve the world's problems. To say that Pal is antithetical to international criminal or humanitarian law represents a very superficial and deceptive reading of Pal, I think. He's a much more complicated and chameleon-like figure. And finally, to conclude, let me take the example of Jawaharlal Nehru. Professor Totani, in her book, has already pointed out the differences between Nehru and Pal. In fact, Nehru was also a very complex figure. On the one hand, he criticized the Pal judgment. On the other hand, he's quite desperate to protect Japanese sovereignty, which is the reason finally India does not sign the San Francisco Treaty, because Nehru does not want that Japan becomes just another Cold War stooge in the American bloc. So to conclude, in a way, the different fractures within Indian actors, Bajpai, Pal, Nehru, it shows a very desperate position of what I've called subaltern sovereignty. On the one hand, all of them, and this is a very strong Indian, anti-colonial Indian intellectual opinion, Gandhi is the supreme representative, but Tagore and many others, they think sovereignty is something evil. Sovereignty creates violence, it creates racism, it creates imperialism. But on the other hand, many of them, not all of them, not Gandhi, but Pal, for example, or Nehru, they would also say, well, but on the other hand, we need sovereignty to protect ourselves. There's a very fascinating moment in the Tokyo dissent where Pal says, I am not in love with the concept of sovereignty. But then he says, however, in the post-war organization, sovereignty is still the way international relations is organized. And this is a tragic consciousness. They all know that sovereignty creates sovereign violence. They want global justice. But in that colonial moment, they still step back and say, no, maybe we need post-colonial sovereignty. But today, thinking back, there has been a lot of discussion about genealogy, Tokyo to Hague. As a historian, I'm much more interested in ruptures. I don't think it's very helpful to take a trial as a precedent when one set of colonizers punished another set of colonizers, giving, apart from India, China, and Philippines, no voice to the colonized, no voice to the Indonesians, to the Hong Kongers, to the Malayans, to the Burmese, to other victims of Japanese atrocities. The trial was about colonialism. Somebody said yesterday colonialism is overstated. The entire trial was about colonialism, about Japanese colonialism. But today, I think we have far better exemplars to take. And we also need to take of creating not a genealogical way of thinking where Tokyo becomes this prefiguration of the International Criminal Court, but we need to think about how to fight against any kind of racism and imperialism. The reason I find Shklar's work so inspiring is because Shklar took the experience of racism, the horrible atrocities of the Holocaust, to think about fighting against racism and colonialism anywhere in the world. And that is the intersection between anti-racism in Europe and anti-colonialism, anti-racism in every part of the world that we need to fight those battles today. Thank you very much.
Okay, thank you, Dr. Banerjee. I thank each one of the panelists for their stimulating presentation and for keeping the time limit more or less. But still, since we haven't got much time left, I just want to open the floor right away for Q&A sessions. And if you have any question, then before you raise any question, identify yourself and indicate whom the question is addressed to, if possible. Thank you. The floor is open. Professor, I see one hand here.
David Crow. To Professor Banerjee. One of the criticisms of Paul's judgment was that he was influenced by Gandhi because they were both Bengali. But I'm more interested deeply in both what you mentioned briefly, Gandhi and Tagore, and if you could expand a little bit on that, which I find very interesting because they're such powerful figures in India at that time.
Yes, Yuma Tutani from the University of Hawaii. I have two questions, and anyone who could address my questions. One is Professor Bhagwat said something to the effect that the Tokyo trial suppressed the voice of Korean victims. And to a similar effect, Dr. Banerjee said that the Tokyo trial was about colonialism. I've heard these comments made elsewhere, and these are stated as if they are self-evident. But I don't necessarily see it that way. And the Tokyo trial was about war crimes and crimes against peace and crimes against peace. It was not mandated to deal with colonialism. If you if you try to address the Japanese wartime leaders' crimes against its own people, including the colonial subjects, and therefore some prosecutor efforts should be made with respect to crimes targeted at colonial Koreans, colonial Taiwanese, colonial Micronesians, and things like that. If the statements are framed that way, what you are saying would make sense. But the trial was about colonialism. This kind of statement doesn't make sense to me. So if you could, any of you could address this, my comment, I appreciate it. The other one is Professor Bhagwat invited us to compare the IMTFE with the other allied contemporary national level proceedings in Asia for us to have a better understanding of the quality of the procedural fairness. And I totally agree with you that this is an important exercise for us to do. Perhaps some of you or anybody in the audience could give us some specific examples, and preferably not just the Yamashita case, because I think quite a bit has been written and said, but perhaps some other lesser-known Class BC war crimes trials, with, say, those held in the Dutch East Indies or those held by the Australian authorities, the Filipino trials, and so on and so forth. If someone could address this question, I appreciate it. Thank you.
I'll take one more question and then bundle them together and then ask the panelists to answer. Okay.
Bill Pace with the Coalition for the ICC. I'm interested in the panelists trying to assess what they know about the Tokyo Tribunal deficits and challenges, and compare those to where we're at if you know the situation with, say, the Rome Statute, the International Criminal Court. Because in particular, something like the translation and interpretation issues are still enormously difficult, I think, and challenging. And you go 5 meters outside of the court and people do not understand this in the world. So, but I would imagine on the topics that each of you addressed, there might be some lessons learned that, have we learned the lessons? Are they being implemented, or are there challenges from your perspective from then that still need to be addressed today? Thank you.
Okay, thank you very much. There are 3 questions from the floor. It's Dr. Banerjee, would you answer the Professor Krauss' question.
Microphone.
Long day. Thank you very much for your question. I think the relation between Gandhi and Pal is really complex. There is an argument given by the Japanese historian Nakajima Takeshi that Pal was influenced by Gandhi. I have not found any evidence about that, excepting in his book on Hindu law in 1958, where he says, I agree with Gandhi's concepts about nonviolence and so on. However, I do not agree with this non-industrialized kind of perspective of Gandhi. However, in some ways, the parallels go deeper. In my book, which has just been published, The Mortal God Imagining the Sovereign in Colonial India, which is an intellectual history of ideas of sovereign rulership in colonial India, my argument has been that in many anti-colonial Indians, when they were attacking colonialism, they said that at the root of colonialism is something far more insidious, the idea of sovereign statehood. That one nation or race or one religious community organizes power and then uses that power to commit, aggression and conquest everywhere. So they said that if we are going to challenge colonialism, we have to also challenge nationalism. These are the famous Tagore lectures of the 1910s, for example, where Tagore goes on a lecture through the United States and Japan saying nationalism is a terrible thing. And others say that it's also about challenging sovereignty and so on. This is not the only leitmotif which is present in anti-colonial Indian thought. Many anti-colonial Indians also think nation state is good. But this is a very powerful element which has been ignored by later histories. It's been ignored because this kind of anti-sovereignty attitude does not fit very well into a comfortable trajectory of nationalist historiography. But I think Pal was in a way representing the spirit of his age when he was making these virulent critiques against sovereignty from the 1920s onwards. And this is what makes him in many ways very similar to the anti-sovereignty critiques given by Tagore or Gandhi or many other people. Now, coming to Professor Totani's question, well, I think crimes against peace is exactly about colonialism, because crimes against peace for me is about aggressive war. And the problem that Keenan landed up in was to say aggression and conquering other territories is bad for Japan, but we are going to forget all the other European aggressions which had happened a little bit earlier. So he says in his famous 1950 book about international criminal law that, some kinds of aggression have happened through the natural, cultural, and racial superiority of some people, in brackets white people, which has been happening through centuries. But the aggression which Japan has done, the crimes against peace has done, we must punish them. Now this takes a feat of gymnastics which might make sense in the context of a trial, but which doesn't make a lot of sense to me as a historian. So I do think that crimes against peace automatically brings up willy-nilly the question of colonialism. It did bring that up your scholarship has of course addressed many of these issues, but if they look at the Tokyo trial archives, in many of the discussions which are not part of the published transcripts, but which are exchanged, the memoranda which are exchanged between the judges, Benar, Rowling, Zarianov, the Soviet judge, and of course Pal, they're all actually talking about imperialism and colonialism in these unpublished drafts between each other. They are not, so I would say definitely, and just looking at it from a historical perspective, why did Japan go on its spree of conquering other countries, of committing atrocities, of committing crimes against peace? It is because of the history of Japanese colonialism. So even if we think, at the end, it is about Japanese colonialism. It is about so the question of colonialism is for me central to the trial. Of course, then we might all differ about what we mean by colonialism. But from my perspective, it is a trial about Japanese colonialism and about the deliberate forgetting of many other colonialisms, very conveniently, but which were not forgotten actually within the trial when the different judges were talking to each other about that. Thank you.
Thank you for these questions. This for me has been the best part of the conference, just hearing what's on people's minds. I'll address Professor Totani's question about, I think you're right. I think it was the suppression of voices. Suppression was an ill-chosen word on my part, because I think it's more an image, almost an architectural image of process, where you have certain kinds of structures and then the substance flows in like water in certain configurations and not other configurations. And so why no Korean judge, for instance, that's not about suppression per se, right? It's choices that then, there are certain kinds of substantive results from that that are impossible, obviously, to measure. Or, for example, from Zach's talk yesterday, the witnesses related to Unit 731, or so they're not suppressed per se, but the way the trial is set up, that's not their forum, okay? And maybe they have other fora. And on the lesser-known trials, that's a tremendous addition that's just coming in now through your scholarship, and I'd say maybe Barak Kushner's and Kirsten Sellar's, and a number of others, including Kirsten von Lingen. So I think that, either of you would be best situated to answer that question, but not necessarily this panel.
Professor Takeda, could you take care of
Yes,
the Bill Pace question?
I don't know if I can take care of the question, but I'm sorry, I'm not too familiar with the interpreting system or translation system at ICC, but I had an opportunity to visit ICTY 5 years ago, and I was quite impressed by how systematic their translation and interpreting was done. And these are highly professional, trained interpreters. And a couple of things I thought about in comparison or in parallel to what happened at the Tokyo trial were that first, many of the interpreters at ICTY I believe, came from the former Yugoslavia. So it's a bit similar to the situation to the Tokyo trial, because interpreters were basically interpreting at the trial against their former leaders, and I think similar thing can be drawn with ICTY. And I interviewed some of them, and I found that they were, regardless of where they come from, they go through very difficult proceedings. They work with witnesses and defendants, and they talked about emotional strains and so on. And but I understand that there's kind of counseling services provided to protect the interpreters and the safety and the welfare of the interpreters and so on. So I thought these are very mature, very systematic, exemplary system of interpreting and translation at ICTY. I think when you deal with multilingual courtroom, there are issues, problems inherent in that kind of environment, and you have to deal with those things in the best way you could by having professionally trained interpreters. If you can't find professionally trained interpreters, you have to, I understand ICC provides interpreter training, which is fantastic, I believe. And also the error correction mechanism that was also in place at the Tokyo trial, and that is used at ICTY and I believe at ICC as well. So as long as the error correction mechanism is there and professionally trained interpreters are performing, and I also understand that those proceedings are videotaped and broadcast. I used to watch ICTY proceedings, like a 30-minute delay on a website. So there's little room for interpreters' possible transgression undetected. So that kind of system is also good. And I don't know if I'm answering your question, but to me, the system you have is exemplary, a very good system. Yeah. I don't know if I couldn't.
Thank you very much. I know you said you have something to add.
And Numa Tatani's question about the fairness of the trials, I can only say something, I think, about the Netherlands East Indies. Maybe Robert and Sandro can chip in if they want to add. I think it's very hard to say something about the fairness overall, so to say, because you may know we had about 12 courts in the Netherlands East Indies that deal with war crimes. And I think each of those courts kind of can be judged, so to say, differently. I think it greatly depended actually on the judge that was involved, how fair the trials were. I mean, some comparisons with Tokyo, all evidence was omitted, could be omitted. In the case of the Netherlands, hearsay was often allowed in court. We definitely had also an interpretation problem, that not enough interpretation, actually not enough defense counsel, as you may know as well. So these were big problems. People had to deal with numerous cases at the same time, not enough time to translate all the court documents. So these are some of the things, and also the fact that some of the prosecutors didn't even have legal background. So you can imagine that these are a few of the kind of elements that contribute to the unfairness of the trials. But I find it very hard to give one conclusion at the moment. I think we really have to look at each particular trial to say something about the fairness, but they might have a different opinion or something to add. So.
Okay, you want to add some more? Okay.
I just wanted to add one more thing in response to the colonialism question. I think, for me at least, colonialism and war crimes are very closely related. And I mean, I don't think I know of any colonialism which has not committed war crimes. In the specific, I don't agree with Paul's judgment. Let me make that very clear. That I think he goes far too far in providing an apologia for Japanese sovereign violence. But one of the main reasons I think probably he does that, it's never stated, is of course I think the Bengal famine. He would have been a witness to it. The Bengal famine was, I mean, all researchers more or less agree, was colonially engineered by Churchill. Churchill has some amazing statements like Bengalis are breeding like rabbits. Basically, they need to be exterminated maybe. And that left about 2 to 3 million dead. And that's really as much of a crime as one could imagine. And Pal is in Bengal right then. And so I think the fact that he's really talking about the brutalities of the Western powers, one has really to keep the Bengal famine and similar other things in mind. Of course, also the fact that Pal later writes this in his 1955 book, that the Dutch and the French are using the trials to re-legitimate control of Indonesia and Indochina. This is something Lisette and my colleague Anne-Sophie Scheffel have been working on as well, the use of the trials to re-legitimate colonialism. So that is why I do think colonialism, war crimes, crimes against humanity, imperialism very broadly, these are all very entangled issues that we do need to think about.
Thank you. All right. Now there's a second round of questions. Yes, Philip, and then young lady in front of you, and then, okay, you, Professor.
Thank you very much. A quick question to Dr. Banerjee. That goes back to politics. I'm sorry, but I was too interested in this. I picked up on two things that you said. On the one hand, that the selection of the Indian judge was something that was sort of in the political sphere or geographical representation, if you want to use the ICC jargon. And the second thing, that Judge Pal had already written extensively prior to 45-46 that displayed clearly his inclination or his opinions on colonialism, on these matters. Therefore, my question, was it not clear what position he would take looking at the confines of the Tokyo Tribunal, and that he would actually be rather vociferous against already the jurisdictional basis of everything? So could one deduce from that India sort of played a card in order to, a political card, in order to sort of stick the boot in, or is that too far venturing into whatever it is? Thank you.
Thank you all for this fascinating talks. My name is Zhang Wanlu from Leiden University. I have a question to Professor Takeda. The interpretation is always very interesting aspect, can be neglected in legal discourse, so I find it very interesting. Because in the work in international justice, we deal with like English, French, and there are already like arguments built up from the difference between the two languages. And then that's why we have the authentication, like which version is the authentic version of one legal instrument. So I wonder, has it ever been discussed, like in Tokyo trial, which version is the authentic one, or if they're equally authentic, like does it necessarily mean they carry the same legal weight? So maybe it's just factual information or any like scholarship or literature you can inform me. Much appreciated.
Professor Cribb?
Thanks very much. Really 2 points of information. One is that in the immediate aftermath of the war, there was no interest at all in Korea in war crimes trials of Japanese. There was no demand amongst Koreans for the bringing to account of the Japanese authorities. It's a striking absence, especially in comparison with the Philippines, with Singapore, with China and other occupied regions. The other thing is that Japan's expansion was consistently framed as decolonization. So Manchukuo was created to decolonize Manchuria from Chinese rule. There was a decolonization of Inner Mongolia. The invasion of Southeast Asia was conducted in the name of Asia for the Asians and it ended up with the creation of client states under Japanese domination. Now, we all know that there was a strong element of sham in that framing, that anti-colonial framing, but the anti-colonial framing was not entirely without meaning. So,
it's my day of forgetfulness. So to answer the first question first, Richard Miner first said that Pal was the only one. I think he was the first one, I'm not sure. He says Pal is the only one to have an international law background among all the other judges, which was then lambasted by later scholars. But actually Pal did have international law background. But the problem is the only source is in French. So that's why I think a lot of Anglophone scholars have neglected this source. In 1937, there was a Congress of Comparative Law at The Hague. And Pal was actually the special rapporteur for the legal philosophy section. And many of the people Pal later cites in his writings are from that 1937 Congress. So Pal definitely has an international law background, and there is a misconception in some of the, I guess, non-Francophone, Anglophone scholarship which has neglected this source. The Pal's writings, the problem is, in his writings before the Tokyo dissent, he never speaks openly that colonialism, I mean, he never speaks very overtly, it's very subtle, that, British colonialism is bad or something like that. What he does is, I'm speaking of ancient India and Hindu law, and their, sovereignty is bad, and when law is tied up to sovereignty, it is a very bad thing. If somebody had actually read those writings in a nuanced way, they would have understood what Pal was going to do. But nobody was going to look at Pal's Hindu law writings in order to understand what he would do, what a mess he would make against colonial sovereignty. So it would have needed quite a bit of training. But in the particular case why Pal was chosen, it's actually very simple. And Nariaki Nakazato has done fantastic archival discoveries about this. So basically, the government of India, which is still then the colonial government, they made two selections. One selection refused, second selection, another Indian judge refused. And then they sent out to all the, so India has different high courts. So they sent out letters to all the different high courts, to the chief justices, asking that please ask your Puin judges which one of you wants to come to the trial. And Pal's was simply the first letter agreeing which reached the government of India. So it was a bit of kind of serendipitous logic, but it's also that people had not really carefully read his other, which in a way is actually a very paradox of colonialism. In some ways, the British never fully understood Indian intellectual thinking, and the British never had a full grasp grasp of why Indians were thinking about sovereignty and anti-sovereignty and so on. They just didn't get it. And in a way, Pal's fallout was a failure of colonial hegemony, if one wants to put it that way.
Just a general, very quick reflection on, again, this architectural image of the power of process. I'm so struck, I'm a little overwhelmed actually by being in this space, and I remember coming to this courtroom back in the day before the Nuremberg Memoriam was set up and being told absolutely impossible to have tourists and visitors visit the courtroom on a regular basis because of EU privacy laws. The courtroom is a working courtroom. You can't just walk in the middle of somebody's trial. It's impossible. It's an unsolvable problem. And the solution was architectural, literally, right? Which was to install these plexiglass windows where you can look down and not hear an ongoing trial, but you can see the space. And I realize it's all going to be obviated by the Nuremberg Principles Academy taking over the entire part of this building, which is fantastic news. But sometimes the way problems are solved are addressed by certain procedural innovations, or again, they don't address certain kinds of problems. But what was formerly an insoluble problem is now a complete non-issue. And so sometimes that can be the power of process.
I'm not a legal scholar, and I'm not familiar with the authentication issue. But under the charter, under the title Fair Trial for Accused, the Article 9b states language. The trial and related proceedings shall be conducted in English and in the language of the accused. So it does refer to the proceedings, what languages are used in the proceedings, but it doesn't talk about what language is the authoritative? I don't know what to say. The official language of the documents or whatever. But correct me if we have a lot of legal scholars here, but none of the judges was able to read Japanese. So I would imagine that everything in although the evidence was provided both in English and Japanese, all the documents used as evidence had to have two versions, English and Japanese. But I don't believe the Japanese version was used as the official evidence because the judges couldn't read Japanese anyway. And all the language disputes were how to translate certain Japanese words into English, not vice versa. They never had disputes over how to translate English words into Japanese. For example, Nankin Jotai, there was a word, Nankin Jotai. Japanese, the defense side wanted to translate it as protective custody, but the prosecution side wanted to translate it as confinement or house arrest or light confinement or something like that. So those disputes were discussed, so how to translate certain Japanese words into English, but never vice versa. So I would say that English was the official language. I would ask for help from specialists.
Okay, we have only 4 or 5 minutes left, so if anybody has a really burning question, then I'll take 1 or 2 and just before closing this panel. Yes.
Thank you very much, Klaus Rackwitz from the Academy. Power of process and reality. You mentioned the fact that there have been no acquittals. You mentioned the fact that this raised suspicions, and you mentioned defense in that context. Now, in the first trial against Lubanga at the ICC, the defense lawyer, Maître Mabille, described the situation in which she was, and many defense lawyers are, quite nicely. She said, there is a huge desire to convict. And I'm pretty sure that beyond all procedural safeguards that you will ever allow defense to have, whether it's tripling their resources, whether it's whatever it is, this desire to convict that might even affect the judges, but certainly affects large parts of the public, i.e. the victim side. This desire to convict is never ever going away. Would you know any procedural remedy? Because I don't see any.
Well, absolutely. I mean, it's part of being a good prosecutor that you want a case that's going to be an exemplar, right? And in a modern context, you have choices about how resources are used. And so, again, I've just revised this looking at the Tokyo trial, looking at that dimension of the Tokyo trial in terms of thinking, well, I think it actually can be used to show that they were good prosecutors. And, it still stands that it's a boost to the procedural legitimacy on some level of the Nuremberg IMT that the judges said, look, this economic responsibility dimension is not succeeding, we're rejecting it, so it results in these acquittals, for better or worse. But that it somehow delegitimizes, albeit mildly, the Tokyo Tribunal to not have the acquittals. I think it doesn't, it's just neutral.
Actually, as you know, the defendants were, at the Tokyo trial, the defendants were represented by over 100 attorneys. The 3/4 of them Japanese and 1/4 American, plus support staff. The defense opened this case in early January 47 and finished this presentation 225 days later. And defense consistently argued that the trial could never be free from substantial doubt as to its legality, fairness, and impartiality. This is the defense position throughout. But I don't know how well this was heard.
What do you think, Judge Song? What do you think, Judge Song? No, I'm serious, because we talked, this is maybe a little unfair, but we talked before, and Judge Song said, well, I didn't know a lot about this trial before, but now how can you can barely call it a trial?
No.
And I'm wondering if you've revised that assessment.
I'm responding to you.
Well, so were Japanese Americans involved? I think there was discussion maybe at a dinner or something that a lot of interpreters, I think Yuma mentioned this, that interpreters might have been Japanese Americans, but there is one woman that we know of named Grace Kanode, K-A-N-O-D-E, I'm not sure how she pronounced that, it could have been Kanode, who was a lawyer in the United States and goes to the Tokyo trial and does legal work. I am not clear what it is. Shana Tabak, who was at American University, is now, I think, at Georgia State and Emory, has written about this. Kanode worked as a prosecutor on the prosecution team for the trial, and in fact, was one of the very first women ever to have made an appearance at an International Military Tribunal. She was one of something like 4 or 5 American women involved. So there's at least one that has Japanese ancestry, but we to date don't know a lot about the quality or content of her work.
Very much with your a nice reply, and we have to conclude this session. This is 12:47. Thank you very much.